with us. We're going to jump over to 2606, and we're going to ask for Senator Barrett, if he will, to give us the explanation of that.
Let's see that. Yes, Senate Bill 2606 will clarify it does two things. First, as far as the suspensions go, if you handle a lot of DUI cases in any court in the state of Mississippi, there's a question of the suspension date as it relates to a conviction of a DUI first or second. So what this would do is specify on line 128 and 129, the first day of any 120-day period for your suspension shall begin on the date the judge signs an order for the suspension. As it stands now, I think that has been the intent, but it's not consistent across all justice and municipal courts. I think providing a certain date upon which the suspension date would start would be beneficial. That is the first change. And the second change, as proposed in this bill, would be regarding aggravated DUI. That is line 286 is where it begins. The really meat of it is 305 through 336. And let me say the premise behind this is based in an equal protection claim. As you all know, under a DUI, zero tolerance is 0.02. Anything higher than 0.02. Commercial driver's license are 0.04. Anything above that, and what is deemed as the legal limit for someone who does not possess a commercial driver's license or is not a minor is a 0.08. So if you are 20 years old, 364 days, you're 1 day short of your 21st birthday. If you get in a accident that causes mutilation, disfigurement, it disables someone, destroys the tongue, the eye, everything listed in the statute, you are held to a standard of 0.02 as opposed to the 0.08. Now, interestingly, you are a minor for purposes of the law. You're under 21, and you are not prosecuted as a minor. You are prosecuted as an adult. So if you are found guilty, you would be sentenced to the Mississippi Department of Corrections to a sentence as defined in the statute, which I believe is 5 to 25 years. So the purpose behind this bill, and I can just say it succinctly, is if you are going to be charged in adult court, you should be held to the adult standard. If you are 18 years old and you are driving under the influence and a wreck, whether it's your cause or someone else's cause, my thought is you should be, if you're charged in adult court, you should be charged with the adult standard. You should be held to the adult standard. Anything otherwise would be a youth standard, and quite frankly, I think there's a equal protection argument that if you're 20 years old, 364 days, or whatever number you put it on, you should be held to the adult standard if you're charged in adult court. That's the explanation of the change that I've proposed, Mr. Chairman, and I yield for any questions.
So going back to that second point first, just for those of us who don't do DUI stuff, are you suggesting that these 18 to 20-year-olds should be charged as an adult, not as a juvenile, right?
No, sir. What I'm saying is if you are charged, if a district attorney's office charges you with aggravated DUI under the statute, you should be held to a .08 standard if you are under the age of 21.
Opposed to what?
Right, as it stands now, it's a .02 standard. Because it's a zero tolerance. Any alcohol for a minor. So if, for example, if you were in, let's just presumably say my district, your child was, and hopefully this never happens, but if he's 18 years old, is in a car wreck that causes a mutilation or a disfigurement, he's 18 years old, and he's charged with aggravated DUI as an 18-year-old, and he blows or is blood tested or is urine tested, and let's just say he tests in at .04. That is the burden the state has to prove that he was over .02. The state doesn't have to prove beyond a reasonable doubt that he was over a .08. All they have to prove is that he was over the zero tolerance. My proposition is, if you are going to be held to an adult sentence, you should be given the adult standard of a .08.
Other questions? Senator Hickman?
Thank you, Mr. Chairman. My question actually deals with the first part of the bill. I think we passed the first part last year, right?
That's correct.
And this is my question, and I may have asked this last year, I just can't remember. When we say, when the judge signs off on an order, that still theoretically could be days later after he issues the suspension.
Yeah, and that's a great question. In my districts that I practice in, and I'm gonna say there's 10 of them, unless you provide the court with a court order, there really is no court order. What they generally sign in my districts are the jackets on the front of the, whatever the tickets are in. Yeah, and they do sign the ticket when they mail it in.
Basically, us as good attorneys, if we provide them an order that day and they sign it, it starts that day. I
Correct.
mean, which is still better than what we have. I just wanted to clarify that because
Correct.
sometimes it's like 3 or 4 weeks, 6 months before the suspension starts, anywhere in between. So I appreciate that. Thank you.
Yeah, and the confusion sometimes is with at least with my clients and maybe some of your clients, there's a presumption that, well, I got charged with a DUI, my 120 days begins when I got charged. Or when I went and pled not guilty or guilty, whatever it may be. And I think this just, makes it succinct that, hey, when it is ordered, court ordered, is the day that it starts.
All right, I would like to ask Commissioner Tyndall, because I had this conversation with him earlier in the week about the mechanics of that on their end. And I just want, I'm for what you're trying to do. I just want to say, I don't want us just to blindly pass something thinking that it's going to just happen, because there are mechanics involved in getting it from the order to the folks that actually do the suspensions. And I would like to hear from Commissioner Tyndall about the processes there and how we might could coordinate what you're doing to make it work. Which could use the microphone for our folks listening online.
There we go. So I talked to our team about how this works, and I understand the frustration. You go into court, your client pleads guilty, the judge orders that their license is suspended for 120 days. So they walk out and they quit driving. You've told them don't drive. And then they realize at the end of the 120 days, oh, it was 30 days later that it was actually suspended. So they're having to essentially go without driving for 150. The problem we've got is we're not going to have immediate notice of all these court orders across the state. So we have to get them in, then it has to go through internally the process that we have before it's actually suspended. So theoretically, let's say this goes into effect, you have the suspension, the court orders it, we're not going to get notice for a little bit of a time. And so if they have the mobile ID app, for example, it's still going to show up on that mobile ID that they have a valid driver's license until it's able to run through our system that it's actually been suspended. And so I'm all for what you're trying to do. I'm just, the logistics of it, there's always going to be a little bit of a gap. And you mentioned even from the moment the court issues the verbal order to the time that there might actually be a physical sentencing order, sometimes a day or two. So there's always going to be those gaps in there. Just want y'all to be cognizant of that, that even if this passes, our system's not going to be able to show it up immediately that it's suspended. So there will be those gaps. It might be that we can consider giving credit for some of that time on the suspension from the state or something like that. But we'll try to work through it, but there are going to be some issues.
Senator Hickman had a question about that.
Kind of on the lines of what you just said, is it possible to, if we say the suspension goes in now and you get the order, and I can't speak for Senator Barrett, I don't know if he would want to make some adjustments, but one of the things I'm thinking is either the state could backdate it from the date that it was, start the 120 days there in the system, and I don't know how your system works, or maybe we put a mechanism in where you say, hey, we will do our absolute best to do this in 20 days, and from 20 days, we'll backdate from there. I don't know what the mechanism is, but I do think we have to fix this because, like you said, people are doing 150, 160 or whatever days because it starts really late.
I think the short answer is yes, we can backdate it. It's management of personnel. I mean, it's going to take more time and effort to get 2 or 3 more people to come in and actually backdate all these orders because we get obviously hundreds and thousands of them that come in. So you're going to have somebody that goes in and manually overrides the system to backdate it. The other part of it is, what we try to encourage judges to do is not tell them your license is suspended, but your license will be suspended. You'll get a notice from the Department of Public Safety. But I think everybody still kind of leaves under the impression that their license is suspended right then. So yes, we can do it. It's going to take some resources and time. There's still going to be that gap, but again, we want to work with y'all through this process to come up with a solution.
Senator Barrett.
Thank you. Commissioner, your office has always been very helpful, answering all my questions, working through issues with me and always coming to a resolution. I would just like to see whether or not it is this approach or what you suggested, because I always tell my clients, as it stands now, you will receive notification from DPS when your license are suspended. So I would just like there to be in writing, hey, your license are suspended on this day, because in all candor, I've had clients in the past and I've heard from people in my district that they stop driving the day they get the ticket. Court may be 4 months from then, and then they get another 120 days. Well, heck, they've been suspended almost a whole year in their mind, and they're trying to do the right thing. But yeah, thank you for your input. And I'm good with doing anything, but I think it would be nice having a date certain that your license are suspended from date of receiving the notice or court date or issue date or something. But thank you.
Thank y'all.
Senator Hill.
Thank you. Senator Barrett, I'm assuming that that lower limit was put in the law in the past because it's illegal for somebody to drink under 21. But my question is, if we do raise it to 0.8, and I see the equal protection issue that you're bringing up, isn't there another mechanism to charge them with manslaughter or something if it's negligent and they don't qualify for aggravated DUI? What would be the charge if they caused accident and injury like this and it was their fault, they were at fault, like being on the wrong side of the road or something? What would law enforcement be able to charge them with if they weren't drunk enough to make the 0.08?
Oh, sure. I mean, if someone's operating a motor vehicle, at let's just say this went into effect and they were operating it, a minor was operating it at 0.06.
Or even an adult?
Sure. I mean, there are multiple manslaughters that would fit into. There are, you're obviously a vehicle would be a deadly weapon. That could be an aggravated assault.
So there are other ways to charge.
Oh, sure.
them.
There's absolutely other
Pretty
avenues.
serious, with pretty serious charges. That was my question.
Yeah, for sure. 100%.
I actually have a accident in my district that's still under investigation that took the life of a 17-year-old.
Mhm.
If that doesn't come back impaired, I want that person charged with something because they took a life and they were on the wrong side of the road. So my point is, if they're not DUI and they're still causing a death or a dismemberment through their negligence, we can still charge them.
Yeah, I would, you know, as well as I do, I think that's gonna be up to each prosecutor in their own district or district attorney, but yeah, there are certainly other avenues that district attorneys can seek to charge if it fits within the elements of the crime.
Senator Wiggins.
Senator Barrett, I'm to somewhat of Senator Hill's questions. I'm trying to understand, under the aggravated DUI, so the current penalty for aggravated DUI is 5 to 25 years. And then what are we doing? What are we doing with the language that's been inserted starting at line 305 if it's a minor? Are we changing the sentence?
No, if you, aggravated DUI would be still, it would carry 5 to 25 years on line 318 to 320. It would still carry the same amount of time, but this portion of the bill would say if you are charged in what I always call big boy court, you should be held to the big boy standard, which is 0.08.
Help me understand that, because if you're a minor, which is, as it says on line 242, zero tolerance for minors,
Correct.
okay?
And it's really not zero tolerance, as you know. Zero tolerance is 0.02.
2 rather than 0.08.
Correct. So if you are charged with DUI first or second or third, whatever it may be, you would still be held to the zero tolerance at 0.02 if you're a minor. If you are charged with aggravated DUI, which carries 5 to 25 years, and you are charged in adult court, they are treating you as an adult, you should be held to an adult standard, which is 0.08.
Rather than 0.02.
Correct.
Okay. So
So as it stands right now, and I keep using this, but let's just say I'm 20 years old, I'm 20 and a half, I'm almost 21. And I go out on the road and I get involved in an accident and I blow a .06. As the law stands now, I'm charged in circuit court. I'm looking at 5 to 25 years. My body may process and metabolize alcohol better than any adults, but because I blew over a .02, I'm per se guilty of aggravated DUI.
so that understand, if you're a minor, I'm just using name numbers here, 16 years old, okay, and you're .02, that means you're guilty under the DUI. And if it's aggravated DUI, then under current law, you're saying that under current law, they will be sentenced under the 5 to 25 year standard because they're a minor.
If a 16-year-old blew as of today, if they let, I don't like to use a .02 because there's some margin of error. Let's say a .03.
Well, no, hold on. Zero tolerance for minors. Minors in Mississippi are under 21.
Correct.
Okay. And so under the DUI statute, it's .02 for minors.
Correct.
Okay. Not .08. Okay.
Correct.
So then when you get to aggravated DUI, I think what you're saying is it's under current law, you can be convicted as a 16-year-old at .02 and be sentenced to 5 to 25 years.
Correct.
But you're wanting that to go to .08.
Correct.
Okay. So then that leads to the question, but as the law is now, is that not why we have, let's just say, a stricter sentence because you're a minor and you shouldn't be drinking anyway?
Oh, I'm sure that was the reasoning behind it.
But
I don't know that there's any facts to say that a 19-year-old handles alcohol worse than a 22-year-old.
But the effect of this change is that we're effectively raising the limit if you're a minor to 0.08 from 0.02.
Only charged in circuit court for aggravated DUI, which is that subsection only.
But when you say adult court, my memory serves me that actually under the youth court law, it literally states that no, controlled substances or alcohol, implied consent law does not apply to youth court, and so those automatically are taken out from the jurisdiction of the youth court.
That's correct.
So then they are in adult court, whether it's 0.0, when it is 0.02. Because they're
No.
never in youth court, because it's excluded from youth.
Oh, yeah, yeah. I mean, yeah, municipal court, county court, justice court, as you know, those are adult courts. Those don't carry prison time.
Well, technically they do, they just probably never get sentenced to.
No, they don't.
Prison, I'm sorry, you're talking Parchman, not.
I'm talking about Mississippi Department of Corrections. I'm not talking about your local county jail where you can go see your family members on the weekend.
Okay, thank you.
Yes, sir.
All right, Senator Hickman, I think you had a question.
Yeah, just very quickly, again, back to the first point of the bill, Senator Barnett and I was talking, and we absolutely want to see this happen. So we were wondering, would it affect your intent if we, and I think you may have said something like this at last dialogue with the commissioner, would it affect your intent if the bill said that it starts when they receive the notice from DPS or what have you?
No, I
We can
think that's
work on it.
perfect. I think just a starting date of the suspension is what I was looking for.
Absolutely. Okay, well, we can work on that, but we definitely need to make that happen.
Thank you.
Senator DeBar.
Thank you, Mr. Chairman. Thank you, Senator Barrett. So my question is, you were discussing the reason to make it from 0.02 to 0.08, equal protection issues and so forth. Sure. So why should we have a zero tolerance for minors at all, having a 0.02? If you're 18 or 16, why should it not be 0.08 for them rather than 0.02? I don't know the answer to that. I'm sure there was a good reason for it back in the day. But why
I don't know that there was a good reason for it.
So why should we have different standard for a 18-year-old versus a 25-year-old or 21-year-old?
Sure, yeah. I mean, I wasn't in the legislature, obviously. Someone proposed this and it passed. But, you know, I think there's a logical reasoning that someone 16, 17, 18, 19 may not have the maturity level that presumptively someone that is 21 does. I don't know that there's statistics to back that up. I don't know. I'm speculating.
Like Senator Wiggins said, they're subject to jail time. It's not subject to the youth court jurisdiction.
Yeah.
Year-old or 15-year-old. So why shouldn't it be? Why do we have, like on line 242, zero tolerance? Why do we have that zero tolerance for minors where it talks about 0.02 being the standard?
Sure.
Do we have that at all? I don't know the answer.
Yeah.
To your bill. I don't want to do damage to your bill, but you know, if we're going to change it up for aggravated DUI, why not change it up for DUI in itself?
Well,
Equal protection claim arguments that you.
well, I think it's certainly an equal protection issue. Regarding the zero tolerance for a misdemeanor, as you well know, first offense DUI carries 24 hours in jail. Second offense carries up to 48 hours in jail. When we're talking about aggravated DUI, we're talking about 25 times 365 days. Huge difference in misdemeanor zero tolerance at 0.02. And so I think we're talking apples and oranges, but why there's a zero tolerance, I wasn't in the legislature. I don't know.
I think my point is, the bill goes forward, if it makes out of committee, that may be a question that comes up later that I think you might want to have an address.
Sure. Yeah. I can appreciate that. Yeah, I agree.
Thank you, Mr. Chairman.
Thank you. To Senator Barrett, on the equal protection argument, you're talking about treating similarly situated people differently.
Correct.
So they're not similarly situated though, in the sense that 21-year-old and older folks are legally allowed to purchase alcohol. Those under 21 are not legally able to purchase alcohol. So you could make the argument that if I'm 21 and I've drank a couple of whatevers, that I may think that I'm okay because I was legally entitled to purchase said alcohol and to drink it.
Mhm.
And I just misread how inebriated I may or may not have been.
Right.
Whereas if I'm 18, 17, 16, I knew I wasn't supposed to be drinking that because I
Sure.
knew I wasn't legally allowed to purchase that.
Sure.
So the idea that I could make the argument, well, I drank 2 or 3 beers and, you
Yeah.
know, I thought I was fine, that doesn't fly. Am I right?
I disagree with you.
On what basis?
Well,
You're making a constitutional argument. I want to hear your constitutional rebuttal.
well, my constitutional rebuttal would be if we are one day short of 21, 2 days short, whatever it may be, that we're not talking as simple as you knew you weren't supposed to do it and you did it anyway.
That applies to every crime. I mean, if I'm voting illegally, because I haven't quite turned 18 yet, I'm 17, but, you know, I'm out casting ballots, I'm still breaking the law.
And I-
based
and
on
I-
One day short.
Well, I think the difference is the punitive measures that are handed upon, whether you're voting illegally or not, would be the same if you're 18 or if you're 45.
But I knew I wasn't supposed to because I wasn't legally entitled to do that. In
Well-
this argument you're making, you're trying to make an 18-year-old and a 22-year-old the same.
No, yeah, I get what you're saying. Here's the deal. You can call it equal protection. You can call, and I said equal protection because, quite frankly, I think it is an equal protection issue. So to answer your question, what that is, I think the state has a problem with the law as it is currently framed. It has not been brought before court, and thank God, that's what we have courts for. So it may be brought in the future. I don't know, and I'm not a judge, but what I do think is not only would it be an equal protection issue, it's also a common sense issue. It's a moral issue. If you are charging an 18-year-old boy, girl, whomever it may be, who is a .07, they're a fraction from the adult standard, they are going to prison for presumptively 5 to 25 years, as the law is currently framed. And I hope it never happens to anybody in here, to their child, but it has happened to somebody in my district's child.
Appreciate your argument.
Yeah.
I don't think you've made the distinction, but I appreciate your argument.
Or-
All right. Other questions, Senator England?
Thank you, Mr. Chairman. And Senator Barrett, I think you may have answered my question on this. We're dealing with aggravated DUI here, which again carries a maximum of 25 years, but it also has a minimum of 5 years. Is
Correct.
that correct?
Correct.
Okay, so what your bill does is we've got that minimum of 5 years, and that's where I think I stand with you on this in having the standard be the same for any individual, because we do have a minimum of 5 years there. So you're describing situations where a judge may be able to take into account, age of, 17 versus 18 or 20 or whatever. And I don't do criminal law, but the fact that we have a maximum, a mandatory minimum on this, which I like having it.
Sure.
Your bill just brings everyone that's subject to that mandatory minimum to the same standard of proof, to be charged and convicted of the crime of aggravated DUI. Is that correct?
That's correct.
Okay. And again, I don't practice criminal law. If a minor is, the chairman was mentioning, if a minor was drinking illegally under the age of 21, is there another crime that they could be charged with for that at the same time?
If in a vacuum, no, not that I know of. If they're disturbing the peace, if they're doing other things outside of that, yes.
Okay, because I do agree that it's wrong for somebody that's drinking under the age of 21 should know better. But under this statute of aggravated DUI, we've got them facing a mandatory minimum. I was wondering if there was another crime there that they could be charged with to kind of hit that.
Yeah.
Okay, that answers my question, and I think the other part of the bill, if we can get the date worked out, I think that's
Sure.
fine too. Thank you, Senator Barrett.
Yeah, thank you.
Senator Simmons, I think, had sought recognition. I think he left to sit. Anybody else? Senator Wiggins?
I have a motion, Mr. Chairman.
Oh, I'm sorry. State your motion.
My motion is that, we delete lines 305 to 336. That's my motion, or an amendment, I should say.
Okay,
I have an amendment. That'd
Alright.
be my amendment and be allowed to speak on.
you're allowed to speak to it.
Thank you. As you can tell from my amendment, it's removing what sounds to be like some troublesome language. I understand where Senator Baird is going, but the reality is that minors shouldn't be drinking. I think it's a deterrent effect, and if it remains in there, then we're lessening the penalty for minors, and arguably could be saying they could drink at .08 and not .02, which is lessening. And the bottom line is you just can't do that as a minor. So I think by taking that language out is good. And then the 120-day, it leaves it in, which is an issue, and I think addresses it.
All right, Senator Barnett,
Thank you, Mr. Chairman. I'd like to speak.
you are recognized.
I understand Senator Wiggins' intent was that every person who was below 18 was able to purchase alcoholic beverages. And the 18-year-olds in my assumption has always been that target age that's always catching like about, are we old enough or not old enough? At 18, I joined the United States Army. At 18, I was willing to go and die and to protect all the freedoms of this country and those other people around the world. If I'm 18 years old and you entrusted me to be able to do that, at 18 years old, I think that should be some consideration for an individual to do other adult things as well. Maybe we don't need to strike all of the language that Senator Wiggins is asking about up to the purchase. Maybe we should be able to change a few words that say the consumption of alcohol, because that person may not have went to the store and literally bought that beer. I mean, we have all been there. He could have, or she could have easily as an 18-year-old soldier, there was many days I wish I could have had a beer or something, because there's a lot of stressful things that happen when people are faced with those situations. If you've never been there, then you wouldn't know. There's a lot of 18-year-olds today, right now, who are somewhere in a foreign land that are defending this United States of America. And I would much rather for them to have a beer at the end of the day, help them deal with some things, versus putting them on medications that could possibly cause an addiction. So we need to look at how we talk about 18-year-olds and the things that we think that they are capable of doing or not. So my question to Senator Wiggins, could we find a way to possibly make some other type of amendment to this versus striking all of the language that's before us now?
Okay, so my response to that, thank you for giving me the chance. The response is the amendment and the language there is in no way affecting the actual purchase of alcohol. In no way. What this language is only referring to is aggravated DUI, and that includes lines 305 to 306. This is the penalty section for aggravated DUI, and aggravated DUI is defined as injured when you have an alcohol concentration in your system and you injure somebody in a wreck, be it cutting off their finger or even to the point where they've been put in the ICU, that's aggravated DUI. But in terms of being able to purchase alcohol, this is in no way affecting that code section.
Thank you, Senator Wiggins. Again, my question is that for that 18-year-old person who may have recently came home from being deployed somewhere, had one beer, and there could have been other things on the road that may have caused the accident. But because this person was 18 or below and blew at this level, we're still going to charge this person at a higher standard than we would a 21-year.
So in other words, you're asking for an 18-year-old it to be at .08 and not .02.
I'm asking that an 18-year-old be given the same consideration as a 21-year-old person.
But the consideration, if I may, the consideration is the victim. This is this is a DUI, aggravated DUI. The victim is injured. And whether the victim has lost his finger or lost his heart or lost his nose or lost something, whether it doesn't, really, that's not important to the victim that the person was 18 or 21 or 14. The fact of the matter is they've lost a limb based on the drinking and driving.
I do understand exactly what you're saying when we talk about the victim, but the victim can also be a victim of a 21-year-old as well. And that victim of a 21-year-old, under the same circumstances, will face that 21-year-old will face a less sentencing or less severity than that 18-year-old would for this exact same thing. So I'm not removing the victim anyway, because, you know, and I hate to bring this up again, but, you know, I'm a victim of something that happened as well. And so I'm not just speaking on someone that's trying to make a defense of this, because I am a victim of a violent crime. But I am saying that that person that gets injured by a 21-year-old that had the same disfigurements or whatever may have happened will be charged less than that 18-year-old person for causing the same damage, to causing the same injuries to that victim.
And that's why the law says from 5 to 25. So at sentencing on an aggravated DUI, if a person loses their hand, then the judge and the prosecutor, the judge can take into consideration that the person was in the military, was 21 or 18, was all that, and can sentence them to 5 years versus sentencing them to 25 years.
What does the law say about that individual who was 21 years old that caused the same,
5 to 20, 5 to 25.
and if this person blew under a .08 at 21-year-old, would the punishment be the same? It's not.
No. Yes, it is. It's 5 to 25 years.
All right, Senator England and then Senator Suber.
Thank you. Senator Wiggins, if we accept your amendment, if a minor of the age of 19 blows a .05 and is convicted and ultimately charged of aggravated DUI, they would be subject to at least a minimum of 5 years in prison. Is that correct?
Okay, so let's understand, my amendment simply takes out the amended language. So if we don't accept the amendment, or if we accept the amendment, we simply are doing what current law already is.
Okay, so under current,
That's what we're doing. If we accept my amendment, then all we are doing is doing what's current law that is done in courts all across the state.
so under current law, if a 19-year-old is charged and convicted of aggravated DUI after blowing a .05, they are subject to a minimum of 5 years in prison, a 19-year-old.
That's what the law says.
Okay.
Current law says.
If an individual under current law, same injury, same type accident, everything the same, except the individual is 21, and they blow a .05, are they subject to the same, are they going to be convicted or charged as an aggravated DUI? Or do they have a different standard that applies to that 21-year-old blowing a .05?
Take out the underlying section. If you look at line 286, every person who operates a motor vehicle and commits death, mutilation, disfigurement, or other injury shall be committed to 5 to 25 years on line 296.
Okay, so
every person who commits aggravated DUI their sentencing range is 5 to 25 years.
okay, and let me try to simplify, just to try to speed up here. A 19-year-old can blow .05 and face 5 years in prison. A 21-year-old has to blow over .8 to get the 5 years in prison. And look, if you're saying no, Senator Wiggins, I'm trying to understand it. So tell me why that is no, and because that's what I'm trying to understand. So I'll just restate again. Under current law, if a 19-year-old blows a .05 and is convicted and charged of aggravated DUI, they're facing a minimum of 5 years in prison for blowing a .05. And then same accident, same situations, but a 21-year-old they have to blow a .08 to face that minimum of 5 years in prison. Is that correct?
Yeah, so it's the same way that if you're a 19-year-old and let's take off the aggravated part of this, and let's say you're DUI and you are a 19-year-old and you blow .05, then you are violating the law, okay? And you are sentenced to first offense DUI.
Is there a minimum sentence with that?
There is.
What is the minimum sentence for that?
Look at first offense DUI. Okay, 24 hours. So if you are a 21-year-old, okay, and you blow .05, then no, you are not guilty because you're 21 years old and you are allowed to be drinking. If you are 21 years old and you blow .09, then you are guilty of first offense DUI, which is 21 years old, which goes back to my point about the deterrent effect. When, however long ago when this was passed, the decision was made by the legislature that minors have .02 and non-minors have .08, okay? Because you can't drink if you're a minor.
Well, I understand that what the past legislature has done, but we're changing bills and updating things. That's what we do here. And I just have a problem with what I think is obviously a double standard, and I know that that not everybody agrees with that. So when you mention the victims, would you want to drop the standard to .02 regardless of age for aggravated DUI? Why not?
Well, because those numbers, and I wasn't here when that was done, but it's all based on scientific evidence and blood alcohol and all of that. And there are states who've raised the limits and all of that. So .08 has been the standard in this state for decades. And if you change it, then we certainly are. Commissioner of Public Safety's here, and my guess is he would have to retrain all his officers about what we're doing.
Right. And look, I just say that to make a point. I think that the standard is .08, and when we're applying a minimum 5 years in prison, that's much different than 24 hours in jail, in my opinion. And I appreciate what Senator Barrett's doing here.
The difference is, okay, and let me say, 24 hours in jail is a misdemeanor. Okay, that's a misdemeanor. It is under current law. The decision has been made that if you are drinking and driving, whether you're a minor or an adult, and you commit in that wreck or whatever, you injure somebody, it's a felony punishable by prison time. That's been the decision. Now, if we want to say that whether you're an adult or a minor and you're drinking and driving and you have an accident and you injure somebody, we want that to be a misdemeanor, then that's something this body has to decide. But I won't be voting for that. And this amendment doesn't address that. All it does is take it back to current law.
Yeah, and I agree. Look, I want us to be tough on DUI as well, and I agree we've got a minimum 5 years on an aggravated DUI. I think that's a good thing. I just don't like the idea of based on age, someone facing a different standard of proof to show that they had committed aggravated DUI. When you've got a .05 versus a.
All right, Senator Suber.
Do we know if there's any other felonies that we have different elements for being charged as an adult? Are there any other felonies that there's a different standard or different elements for a minor and an adult that you know of?
Yeah, like your delinquency of a minor, you can't commit that if you're
A minor?
that. There are, I think, maybe even shoplifting, something like that. I'm not sure.
Yeah, I'm just talking about just felonies. Do we know of any other felonies that are out there that we have different set of elements for minor as opposed to an adult?
I don't know. I'd have to look through the whole code. Well, yeah, the chairman is saying different sex crimes depending on the ages that have certainly been upheld. So that's a good example on that. But I think the difference is, if that's the case, drinking driving can and is so serious that, I mean, you're violating the law if you're a minor and you're drinking, first of all. That's just the bottom line. If you're a minor and having sex, you're not necessarily violating the law.
All right, Senator Barrett.
Look, in closing, I'm not suggesting that we do any of that. My suggestion is if you are under the age of 21 and you're charged with aggravated DUI, in circuit court, you should be held to the adult standard. That's it. Senator Suber asked, are there any other felonies that have different elements? And there's not. Sex crimes have different age categories, but the elements of the crime are the same. Penetration of some sort of, so the elements are different. And again, I'm against DUIs, believe me. I don't drink and drive, but I also have children. And I also understand that there are times when change is necessary. And that's, like Senator England said, that's why we're here. Otherwise, there's no sense for us being here. And I just submit it as it is.
Senator DeBar, you recognized?
Thank you, Mr. Chairman. I just want to comment and support of Senator Wiggins' amendment, not because I agree with it, because I think what Senator Barrett's correct, but currently our age of majority in Mississippi is 21 years of age. So we do have precedent saying that if you're under 21, you are a minor, and we can treat minors differently. And so until we change our age of majority to 18, like 48 other states have already done, and we're stuck with what we have. And so as much as I don't like the problems that we have, I support the amendment because we have decided to make the age majority 21 rather than 18, like it probably needs to be. So thank you, Mr. Chairman.
Thank you. All right, Senator Wiggins, to close on your amendment.
Thank you, Mr. Chairman. I think we've heard that. I'll just add to Senator DeBar's point. There's a constitutional precedent that minors, whether we agree with it or not, have a lower standard of privacy, for example, in the education space. It is well-settled law that police officers can come in and search school lockers and all because minors do not have the same level of privacy that adults have. That's a fact. And there is always a distinction that we make in this legislature between minors and non-minors. I go back a few years. We passed legislation that said if you're under 18, you can't do tanning beds. But if you're over 18, when we did some other stuff. 18 minority majority tends to be the delineation in this legislature because minors are minors. And so this is the same thing, and all of my amendment does is take it back to current law. And I'm all for change. People know that I think we need a lot of reforms in this state, but this doesn't happen to be one. And I know I can look at victims and tell them that we have not lowered the standard should their loved one have lost a finger or an arm in a DUI. And I would encourage you to vote for the amendment.
All right, you've heard the closing argument on the amendment. All in favor of the amendment, say aye. Any opposed, nay. All right, a division has been requested. All in favor, please raise your hand. 3. All opposed, raise your hand. All right, the chair is not in doubt. The amendment fails. Back to Senator Barrett. On the first part of the bill, after all the discussion, are we saying we need to make any changes for like backdate or whatever y'all were talking about in the language, or are you good with it the way it is? Senator Simmons maybe has a suggestion.
Thank you, Mr. Chairman, and I'm sorry I didn't say anything when we were on the point earlier, but I really think that the date of the order from the court still is a good way to start the clock to ticking. And I think if we can just work on it as the bill goes through the process on working with the commissioner on if the 120 day is the last day, getting them to put in their system that day as the last day. Because still you're gonna have problems all over the state because different, depending upon the personnel and the various municipal clerks, they're gonna send it at different times. And what's gonna happen in your area, Senator Barrett, it may end up being 140 days. In my area, it may end up being 160, 170 days. I just think that if the law is you convicted and you are suspended according to the law for 120 days, we should be suspended for 120 days. And we should try to figure out a way to try to make that more definitive than the problems that we are having with the clerks getting it noticed to the actual agency and then the agency putting it in the system. And I want to do whatever the commissioner wants us to do because he's always responsive and he's running a great department and I love his leadership. But I think if we can just work on it as we go, Mr. Chairman, through the process, it will be consistent all over the state if we can just put a date at the agency where the 120 day is from the date of the judgment in the court.
Senator Hill?
Thank you, Mr. Chairman. I'll make it brief. I was trying to make a comment before we voted on the amendment in regards to what Senator Wiggins' closing was. We talked about the age of majority being 21 and that minors don't share the same level of privacy as adults. Just wanted to make the comment that we have a situation in Mississippi where hospitals are locking parents out of minors' medical records and giving them the privacy to have to give consent to their parents to see their medical records. And I have a bill moving, it's in public health. And so, and also, you know, age of consent for medical treatment is not 21 either. So I was torn on this amendment on how to vote because we have varying degrees of what we say kids are able to do in various areas of their life. But I think we have a serious problem when we have hospitals saying that kids have to give medical consent, a consent for their parents to see a medical record. It was 12 at UMC. When it came out, it was raised to 14. And I think it's going to be up to the legislature to do something about it to say that a 14-year-old does not have that authority because the hospitals have given it to them. So that was going to be my comment. And I agree with Senator Barrett. I don't want an 18-year-old to be punished at a lower threshold than a 21-year-old for the same crime because of the reasons that Senator Barnett mentioned. We can send them off to die, but we're going to hold them to a different standard if they're 18. So I think we need to look across the board at what's going on as far as how we treat our minors.
Hill?
Thank you.
All right. So I take it we're okay with the current language.
Yes, Mr. Chairman.
Thank you. All right. The motion is, Senator England, title sufficient to pass. All in favor say aye. Any opposed, nay. The ayes have it. Before we rise in reports, we got a total of one whole bill done out of our agenda.
Mr. Chairman,
Yes, sir.
I enter a motion to reconsider on Senate Bill 2606.
All right, you're recognized for that. The motion has been entered. We are going to meet again probably this afternoon if there's time for the agenda. Hang on. And we are definitely going to meet again next week because these aren't even all the bills that we had hoped to consider. And I apologize to Commissioner Tindall for having him up here on like 2 or 3 bills on the agenda that we obviously didn't get to. So we will be back. I just stay tuned because we got to coordinate with everybody else's committee calendars, obviously, in order to accomplish that. And I apologize, but I do love our committee. I think we have really robust, healthy debates, and that's what we're here for, right? So with that, a motion to rise and report. All right. So